Hello and welcome. My name is Ali Goff. I'm the owner and founder of Goff Legal. And today I'm talking to you as a woman who's going to inherit or has inherited, hopefully before you've inherited money, assets, gifts, bequests, whatever you want to call them. Really, we're talking about if you are a woman in California and you're going to inherit money, what should you be thinking about? What specifically should be on your mind? And what kind of questions should you be asking? Now, we represent clients throughout California. We represent couples, men, women, in all facets of life and all relationships, no judgment. And I also know that there's a few things that women, I think in particular, need to know. So I'm going to share that with you now. First up, if you're inheriting money, you should meet with your estate planning attorney and make sure your foundational estate plan is taken care of and done. Foundational meaning you have a will, a trust, power of attorney, healthcare directive, and your accounts are updated and you have beneficiaries on them. You're receiving money into your estate or into your possession. You don't want it to then be lost later to probate courts or conservatorship courts or family disputes or, God forbid, lawsuits and divorces. So you want to make sure that your foundational plan is handled so that when you receive money, it has some place to go. Now, if you're married, fun fact, I say fun fact. I don't know that fun facts are fun in the law, but that's okay. Fun fact, in California, if you are married, if you receive a gift or bequest usually by death or gift to someone during while you're alive, if someone gives you money, it is separate property, which means if you treat it like separate property and your relationship for some reason ends by death or divorce, that asset is yours. Now, it's really, really important that you understand how we protect that asset, which means if you receive money, let's say you have a gift from your mom after your mom passed, and you take it and you put it in a joint checking account with your spouse, it is now half theirs. It is what we call transmuted. It will be turned into community property. And if your relationship ends for any reason, California is a no fault state, any reason, they get half. I don't care where the funds came from unless there's some weird tracing and some things you can do, but do you know how much money you would spend trying to trace where that money came from? Hello, family lawyer bills. We don't want that. So, if you'd like assets that you are receiving to stay yours, put them in a separate account. Put them maybe in a separate trust. We have clients who have a family trust for the husband and wife or husband and husband. And then we have separate property trusts. Let's say one of the spouses has separate property, funds that they've either had before their marriage or have been gifted from their family and they want to keep it separate. We'll create a separate trust just for those assets. You can see how blended families this might work well. If you've inherited a family farm from your family, you want to make sure it goes to your kids, not to your spouse's kids, who may or may not be your kids, who, by the way, when your spouse is gone, may or may not get along with you. So it's really important that we're protecting those assets and thinking about it. So, right, like I said, level one, foundational plan. Level two, where does that asset go? If you're getting cash, investments, business entities, real estate, go to your attorney and say, I would like to make sure these assets go boop, boop, boop when I'm gone. You need to tell them what your goal is. Is it your goal to protect it from divorce, from lawsuits, from fighting family, from ungrateful children? I mean, the list goes on. I can protect it from dang near anybody. But you have to tell the attorney what you want to protect it from or for so that we can set up the right structure, the right entity, the right trust, the right beneficiary designations. Here's the good news though. Let's say you inherit $100,000 and you put it into a separate property account. You're allowed to use that money for you and your spouse. There's nothing preventing you from using that to benefit your family. You want to go on a family vacation and have that trust pay for it or that account? Go for it. You've taken it out to use it versus putting someone's name onto it, right? So there's a difference, and I think that's really important. So, these aren't the most fun conversations to have. I can see how this might be a little uncomfortable, but what if the roles were reversed? Would you want your spouse having their family cabin go to your kids after they're gone? Maybe that's not what they wanted. Maybe that's not what you wanted. So having those honest and transparent conversations. One of the things you might consider is you have a different attorney for this. If you have an attorney that's been representing the couple for family trust planning and you're inheriting money, it might be a good idea to have a separate attorney who's only representing your interests. Why? Because there could be a potential conflict. If we have helped you do your family plan and we're setting up something that your spouse doesn't agree with, we can't help. But let's say you have a different lawyer who's represented you for the family plan. We could represent you in as a beneficiary and maybe creating your estate plan and protect that in its own bad magical little box. Now, you can make your spouse the trustee, you can make them the beneficiary, quite frankly. You want to give it to them when you're gone? Great, we can do that. But we don't just give it to them while we're alive because there's other implications for that. There's other things we need to consider, not just divorce, like I mentioned earlier, lawsuits. What if someone gets in a car accident? What if we want to make sure that, your kids are driving your car? Anyways, I could go down the lawyer horror stories, and I'm not going to. So, as a woman, I think it's important. I've gone through some of the things. I think it's important that you're intentional, that you aren't hasty, that you don't rush. The thing about trust administrations and beneficiaries is usually you have some time to think about this. It's rare that someone dies and you get an asset. If you do, though, if there is some time sensitive nature things going on, assemble your team as fast as possible. This is my last tip for you: attorney, CPA, financial advisor. Again, have your set of people who can advise you on how do I receive this asset? Do I take the investments or do I want them to liquidate it? What are the tax implications of this IRA? What if I have the real estate versus, or something else? Have a team who can advise you as a beneficiary, not as trustee. If you're trustee, you can have an attorney represent you, but as a beneficiary, because the things you'll be thinking about as a beneficiary are different than what the trustee is thinking about. They're thinking about protecting the trust and keeping everyone equal. Your lawyer should be thinking about what is in your best interest. That's why it's important to have your own team for this purpose. So I hope that was helpful. We actually represent women and as beneficiaries on a regular basis. And if that's something you want to talk to us about, you can get some more information on our website, gofflegal.com.